these 6 schedule areas, basically the areas falling in the sixth schedule are the tribal areas of the Assam, Meghalaya, Mizoram, and Tripura. I repeat, the tribal areas of Assam, Meghalaya, Tripura, and Mizoram are in sixth schedule, and the schedule areas and the scheduled tribes in the other states, excluding those 4 states, are in the fifth schedule. So that is the broad distinction. The fifth schedule, the notification is done for including, excluding area, etc. by the president, and in case of the sixth schedule, that notification is done by the governor. And for for the six schedule areas, for doing the notification for creating a new district council or decreasing the area, etc., the governor has to first get the report from a commission which is constituted for studying the effectiveness of the scheduled of the six schedule areas. Now, if we look at the broad distinction between these two schedules, at times they appear to be slightly overlapping and confusing. In case of sixth schedule, there is a provision for a district council which is elected. So there is a council which is called the district council, and there can be regional council also. The maximum members in the district council is 30, that is specified in the sixth schedule itself. As far as the fifth schedule areas are concerned, there are no such district councils or regional councils, but it has tribal advisory councils. And the tribal advisory councils, they have representatives from the members of the state assembly, that is the members who are representing the scheduled tribes in the state assemblies of those areas which fall in that particular state, and their strength has to be up to 3/4 of the total strength of the tribal council. Now, as far as the sixth schedule area is concerned, it is the district council which makes the laws. But in case of the fifth schedule areas, it is the governor who makes the regulations, and before making those regulations, the governor has to should take the views or the recommendation of the tribal advisory council. So here it is the role of the governor as far as the making of the regulations, etc. is concerned, and here it is the district council which makes the laws. So there are certain subjects which are assigned to the district council on which laws can be made, which is not the case. The laws are not being made as far as the fifth schedule is concerned. It is only the regulations. Now, another important aspect, which is basically to take care of the uniqueness of these areas. The uniqueness emerges from the unique customs, traditions, and civilization of the people who are residing in sixth schedule areas or the people who are residing in the fifth schedule areas. So there is a requirement that if there is a certain act of the state, certain law of the state, or certain law made by the parliament, if there is a requirement that a part of that law or whole of that law shall not apply with respect to the fifth or sixth schedule areas, so there is a provision. And the difference is, in case of fifth schedule areas, this power is given to the governor wholly. The governor can declare that such particular law of the state or of the parliament shall not apply to the fifth schedule areas, or will apply to certain areas, or will apply to certain extent in certain areas, or will apply with these modifications in certain areas of the fifth schedule areas. That power is with the governor, both for the state laws and for the parliament laws made by the parliament, as far as the fifth schedule is concerned. But for the sixth schedule, that power is with the governor only in case of Assam. In case of Assam, the governor can declare similarly as it was being done in case of Schedule 5 areas. But in case of Meghalaya, Mizoram, and Tripura, the governor's power are confined to the laws made by the state. And as far as the laws made by the parliament is concerned, that notification has to be issued by the president that this will not apply in the six schedule areas in this particular area, or with this modification, this restriction. So that is a broad distinction in the manner in which that restriction is being done. Now, as far as the fifth schedule area is concerned, the regulations which can be made by the governor, the regulations which can be made by the governor are primarily aiming at peace, progress, and good government. And as I said, this regulation has to be made with the recommendation of the Tribal Advisory Council. And the whole theme of the broad theme, the general theme of these regulations can be peace, progress, and good government. And certain special areas have been mentioned without affecting the broad theme. That is, the regulation can restrict the transfer of land by the scheduled tribe. It is basically with the intention that the tribals don't fritter away with their resources, with their land resources, by inducement or by any other enticement. So it is to protect the land of the tribals that this regulation can be made, and the money lending business can also be regulated in the fifth schedule areas, and the allotment of land. This aspect can also be regulated by the governor on the recommendation of the Tribal Advisory Council. But all these regulations need assent of the president. These regulations cannot become effective unless president has given the assent. As far as the sixth schedule areas is concerned, the district council, here it is the regulation, here it is the law. The district council can make laws on certain aspects like land related matters, allotment of land, keeping land reserved for grazing, keeping land available for agriculture. Of course, this will not include the reserved forest land. Then management of forest area also law can be made by the district council, but again the forest area cannot be the reserved forest area, is to be excluded. Then the how the jhum cultivation can take place, its restriction, etc., and in what manner it can be done, that also a law can be made by the district council. Inheritance of property, marriage, customs, social customs, issues related to this inheritance of property, marriage, social customs, also the laws can be made. And important aspect here is the laws which are being made by the district council have to be assented by the governor. So till such time they are assented by the governor, they have no effect. Here the regulations are made by governor but are to be assented by the president. So this is a distinction here. Another power which has been given to the district council is that they can establish the primary schools, they can establish dispensaries, they can establish markets, etc. And they have also been given, the district council have also been given the power to collect land revenue and power to collect taxes. But again, any law made or any regulation made for collection of land revenue or imposition of taxes, it has to be assented, it has to be approved by the governor. They can also uh, levy they can collect the revenue in terms of the lease which is given against the extraction of the minerals and other resources of those areas. And there will be an arrangement for sharing of the returns emerging out of the license which is given for the extraction of the minerals. And in case of any dispute between the state government and the district council regarding sharing of the returns of the license against the license which has been given, then this dispute is to be decided by the governor in his discretion. This is important. In all other cases where I am saying governor, the governor basically there will mean he will act on the advice of the council of ministers. But here, in case of the dispute which is because which emerges from the issue of sharing of the returns from the license given for extraction of mineral, then the governor has to decide in his own discretion. That is very clearly mentioned in the schedule itself. And the the district council can also regulate money lending business by the non-tribals in the tribal areas. Basically, again, this aspect is there to protect the tribals from the exploitation. So that regulation can be made. And important aspect which can come as which is generally which can be asked is how do you change the fifth and sixth schedule? Do you need an amendment of the constitution? It is not required. Para 7 of the fifth schedule says that it can be changed, the schedule alterations can be made, but that will not be deemed to be an amendment under Article 368. Similarly, Para 21 of the sixth schedule says that that amendment will not be deemed to be an amendment in the Constitution of India. Another important aspect of fifth schedule is that president can ask for the report regarding the administration of schedule areas from the governor, and that report has to be provided. And generally, annual reports are also to be obtained by the governor regarding administration of schedule areas, and the executive power of union, important, extends to giving directions to the state regarding the administration of schedule areas in the fifth schedule. The fifth schedule areas, the administration of schedule areas, the union government can give directions to the state government with regard to the administration of those areas. So the executive power of union is expanded irrespective of the division of power between the state and the union. So these are the broad provisions of the fifth and sixth schedule. I tried to cover both of them in relation to each other so that the minor distinctions become easily noticeable. Thank you.